Segment 3. We depart from Obamacare, gay marriage. In 2008, California voters enacted Proposition 8, a measure that amended the state constitution to limit marriage to heterosexual couples. One marriage, one man, one woman. In August of last year, Federal District Court Judge Vaughn Walker ruled that Proposition 8 violated the equal protection and due process clauses of the U.S. Constitution. Let me read to you two responses to Judge Walker's decision. One, an editorial from the New York Times, quote, "The decision is a stirring and eloquently reasoned denunciation of all forms of irrational discrimination, the latest link in a chain of path-breaking decisions that permitted interracial marriages and decriminalized gay sex between consenting adults," close quote. That's one. Here's two. Legal scholar Ed Whelan in National Review, quote, "Although there are aspects of the opinion that relate only to California, the very grounds on which Walker concludes that Prop 8 is unconstitutional would compel the conclusion that traditional marriage laws in other states are also unconstitutional. The ruling invents a constitutional right to same-sex marriage," close quote. John, which of those two choices is closest to your own views?
Well, I have to say, Ed's a former colleague of mine and a friend, so I have to go with Ed. But you never desert your friends.
Decision number one. Right.
Yeah, never desert your friends. But no, I think I can't imagine even the New York Times would say this is not an invented new kind of right that didn't exist before. Of course it is. I mean, the Supreme Court is never
path-breaking is what their word for invented.
Yeah, they both agree it's new. I do think. Let me say, actually, as a policy matter, I would vote for gay marriage. I mean, I'm fine with gay marriage, but I think the wrong way to do it is by having it judicially imposed over the opposition of the majority of people of different states. So with that, on
the constitutional merits, what did you make of Judge Walker? It's Judge Walker's, yeah, Judge Vaughn Walker. What did you make of his decision?
I thought it was a really poorly done decision. I mean, if you read it carefully, it basically says this law is so irrational, no one could have any reason to actually ban gay marriage that is just the product of hate. So he basically said the majority of Californians,
60% of Californians who voted for it.
The millions of Californians are bigots.
But let me put
I mean, I think it's a terrible. I mean, that is not.
It's not the way to win friends and influence people. But there's another irony about this, because I think, in effect, that he really doesn't understand how conflicted the opponents of gay marriage really are. Most of them will support.
How conflicted the opponents, right?
Yes.
The Prop 8.
Yeah, I mean, many of them are very much in favor of civil unions. Many of them are in favor of an anti-discrimination law which protects people on the grounds of sexual orientation. Essentially, what they believe is that public symbols ought to be determined by public policy debates and not by single judges of dubious constitutionality. And they also, I think, resent the fact that the way in which he did this is he got a bunch of expert witnesses who got up there and announced that all this stuff was irrational, whereas all the people on the other side of this debate, when they wrote about the subject, said, God, we're really not sure about the way in which this thing ought to pay out. We ought to go one step at a time. And it seems to me that to use the word irrational when other people are trying to be prudential just simply fundamentally miscasts the way in which the debate goes. Look, don't ask, don't tell was not my favorite statute. In 1992, it had a lot of support. It died under somewhat dubious circumstances at the end of this particular Congress. But surely the legitimacy and the implementation will be much better having it done through statute than in the other particular case.
Than having a judge.
Yeah, and so I think, in effect, that this case will actually lose when it goes up to the Supreme Court.
It's another 4-4 in Kennedy.
Yeah, but I think Kennedy
I think it's the same thing.
Well, Kennedy in Lawrence versus Texas said that the criminalization.
Tell us about Lawrence versus Texas.
That was its 2003 decision, which said essentially that you cannot criminalize sodomy. And
Texas law.
Texas law, and it struck it down on equal protection grounds, period. And the last paragraph, he says, just because we're committed to decriminalization doesn't mean that we're committed to gay marriage. And it turns out that that's actually a very difficult line to join.
Would you like to hear what Justice Antonin Scalia wrote in dissent?
Yes, rather bitterly, I'm sure.
The court today pretends that we need not fear judicial imposition of homosexual marriage. Do not believe it.
Well, that he's telling the truth in this case, because it's the same doctrine of unconstitutional conditions all over again. If you can't criminalize it, you got a monopoly position, you're the only one who could grant the license, essentially what you have to do is to grant your license to all comers on equal terms, and that would suggest that if you can't criminalize the conduct, you can't penalize it by civil disabilities.
It's very hard to see how the court would go down the road it's gone in the 2 previous gay rights cases and then say, but no on gay marriage, except for this is just more politically controversial than criminal sodomy and so on.
So the court, all right, so unless they step away from or indeed overturn Lawrence versus Texas, which is a 2003 decision, unless the court overturns Lawrence versus Texas, it has to approve by its own logic gay marriage.
Well,
but they won't want to touch it. Is that what you're saying?
You won't want to think so. You would think the logic and the reasoning, I'm completely agree with Richard, the path of the decisions, it's hard to say gay marriage isn't constitutional too. On the other hand, to have the courts saying majority Americans are bigots, Barack Obama is a bigot because you remember from the campaign, Barack Obama would not support gay marriage.
Bill Clinton.
Bill Clinton would not. All the members of Congress who are not voting to, get into this fight are somehow bigots. I think that goes way beyond saying, you can't criminalize.
Okay, so as of the latest development here is this went to the Ninth Circuit on appeal, and the Ninth Circuit has now asked. Actually, I can't remember because
they have a standing issue.
But they have a standing issue. They're trying to slow the thing down, as best I can understand, on whether the Planned Parenthood defenders had standing to defend it in court because
Prop 8
the Prop 8 defenders. You got wrong guys.
I'm sorry, Prop 8. So what I'm asking is this the Ninth Circuit, notoriously liberal, I think, in general, right?
Yes.
Is this the Ninth Circuit saying, whoa,
no.
Even we just want to slow this thing down.
No.
What they're actually doing is they're
trying to insulate the system.
Yeah, they might actually be preventing the Supreme Court from reviewing it, but preserving its effect in California.
That's what you're reading the wrong political tea leaves into this situation. What happens is that the irony is that this is a statute which everybody opposes and nobody has a standing to oppose, is, I think, politically a rather grotesque position. But remember, the state has the duty to defend the statute. It basically played lame. All the interveners came in without official
Governor Schwarzenegger refused to defend it. Attorney General, now Governor Jerry Brown, refused to defend it. Isn't that a dereliction of duty?
Well, some people would think so.
Supposed to stick up for the Constitution of the state?
I actually think it says in the California state constitution that they have to defend it, and they just refuse to do it.
But they did the same thing in the Defense of Marriage Act. Essentially, the government decided to play lame.
So to close out this segment, the Ninth Circuit does what?
I think actually the Ninth Circuit will dismiss it and say there's no standing, and so Judge Walker's opinion stays in effect. Prop 8 is canceled throughout California, but it doesn't go to the Supreme Court. If that doesn't happen, then it does go to the Supreme Court, and I hate to say it, but I think the court, 5-4 with Justice Kennedy and the majority, will uphold Judge Walker.
I don't think they will, actually. I think he'll switch.
Really?
Yes, I do. There's a recent case dealing with
get
religious
that on
liberty.
TV?
Yes,
I would have bet you
here.
$1.
$1?
Well, it's like Trading Places.
The principle is
$1.
Yeah, no, I think in effect that this is a man who puts the fingers up to the winds and he sees that this is not the winning strategy. And look, let me give you a famous.
Richard was going to compliment Justice Kennedy.
No. I mean, there was a famous decision
rectitude
by Justice Shaw who refused to desegregate the Boston school system back in 1852 or 3. And the reason he refused to do it, well, it was famous because it was the basis of Plessy v. Ferguson 40 years later. Right. And he knew that they would be desegregated by political forces, which indeed happened 2 or 3 years later. If that's the way Justice Kennedy thinks the wind is going to go, he's going to reject the doctrine of unconstitutional conditions in this context and keep with the old distinction in Lawrence.